Judicial Independence Podcast. Podcast on the challenges to the independence of the judiciary, access to justice, and the protection of human rights across the European Union. Welcome to this podcast mini-series on the judicial independence in the EU. This podcast is part of the Rule of Law for Lawyers project, led by the International Commission of Jurists in partnership with Free Courts, Aditus, Forum for Human Rights, and Human Rights in Practice, looking into the current challenges to the rule of law, especially to the independence of the judiciary in Europe. These challenges are numerous and in many cases extremely serious and can limit access to justice and have negative impacts on lives of millions of people across the EU. In the 10 episodes of this podcast, we will speak with experts and legal practitioners to shed light at some of these issues, and will discuss about ways to protect and preserve judicial independence so that human rights across the EU can be effectively protected. Welcome to the second episode of the Judicial Independence Podcast. I'm Karolína Babická, legal advisor at the International Commission of Jurists, and in today's episode we're going to look specifically at the situation in one EU member state, and that is Poland. We have seen serious backsliding of the rule of law in Poland, and it's been many years since many judicial reforms have been introduced that attacked the independence of the judiciary in Poland. A number of legal battles followed, with litigation to the European Court for Human Rights and the Court of Justice of the EU. And while the courts condemned Poland for serious violations and a lot of litigation work has been highly successful, the implementation of the judgments is still lagging behind, and so is probably also the EU response to a large extent. So we will be able to discuss on this today with a well-placed expert, Michał Wawrykiewicz. So welcome. Thank you for joining us today.
Hello. Thank you for the invitation.
Thank you. And maybe just a few words to introduce you. So Michał Wawrykiewicz is a Polish lawyer specialized in human rights law and EU law, and co-founder of the Free Courts initiative, who collaborate also on the current role project with the ICJ. And you have also co-founded the Justice Defense Committee for the legal defense and support of Polish legal professionals targeted by disciplinary proceedings, intimidation, and harassment. And you've also been involved in a number of cases over the years, so we're really grateful to have you here today. And there is a lot to cover on Poland when it comes to judicial independence, and it would be great if we could discuss about some of the cases, but also about the effectiveness of these cases. So perhaps just in a very short introduction, let me say that in Poland until now, the key institutions of the judiciary were brought under control of the executive, from first the government taking control over the Constitutional Tribunal, next over the prosecutor's office, over ordinary courts, the National Council of the Judiciary, and over the Supreme Court. So judicial disciplinary and appointment procedures have been put under political control, and judges have faced forced retirement, abusive criminal charges, disciplinary proceedings, including for their application of EU law. So, Michal, you have been involved in a lot of important litigation related to judicial independence in Poland. Can you highlight some of the cases that you or your colleagues have initiated?
Well, from the perspective of the European standards of the independence of judiciary in Poland, the first significant and important case was actually the case brought by the European Commission. I mean, the Article 7 procedure, which was triggered at the end of 2017. But it appeared after a couple of years that this procedure is not effective. It is purely political procedure, not legal procedure. And because of that, it is stuck in the council and it doesn't work. A second important procedure that was triggered by the Commission was the first infringement procedure in protection of justices of the Polish Supreme Court. I would like to remind that in 2017, the Polish government decided to introduce the new legislation saying that actually 40% of justices of the Supreme Court are to be expelled. All of those who are over 65 are to be expelled, including the Chief Justice of the Supreme Court. So in 2018, European Commission started the infringement procedure against that, and they filed the motion for the interim measure, and it appeared that the Court of Justice in Luxembourg issued the interim measure in October 2018. And on the basis of this interim measure, the justices of the Polish Supreme Court were able to get back to adjudication and to continue their mission in the Supreme Court. Also, the Chief Justice of the Supreme Court was able to finish her constitutional term. So that was the first example of effectiveness of European Union institution tools. And that was also a very good example of the cooperation between the European Union institutions and the Polish civil society, because at that time, in 2018, we had a huge support of the Polish civil society. We even were able to settle a coalition of the civil society, which was called Europe Do Not Surrender, to push the European Commission to start this infringement procedure. So that was, as I said, a very good example of effective cooperation between the civil society and the European Union institution. But actually, when it comes to the procedures that were initiated by us, by the Free Courts Initiative, that was a very significant procedure in front of the court, in front of the Court of Justice in Luxembourg, the AK case. That was the preliminary ruling procedure when we had two major questions. If the disciplinary chamber in the Supreme Court, which was created from the scratch by the government, which was completely subordinated to the government, if it is the court, independent and impartial court in the meaning of European standard or not. And the second question was if the National Judiciary Council, which was also created to subordinate this council to the government, to the political power, if it is the independent constitutional body or not, if it is able to appoint judges or not. So that procedure ended up with the decision of the Court of Justice in November 2019, when the Court of Justice described very precisely the criteria, saying that this disciplinary chamber is not the court in the meaning of the European standard, and this council is not the independent body. So that was the first crucial and very significant case that we had the chance to be the representatives of Polish judges and justices of the Supreme Court. But since that time, we have around 50 cases in both Court of Justice and Court of Human Rights in Strasbourg. So now the situation is completely different from the legal point of view when it comes to the confirmation from the European courts that all of these actions, all of these legislations of the Polish government within last, let's say, 7 years, are not following European standards.
Yeah. Yeah, thank you so much for this overview. And of course, the question then is, even if you manage to get these really good judgments that really confirm the claims, what was the impact actually? Or, could you see some kind of an impact on in Poland, on the government kind of following the judgments? And related to this, the really maybe crucial question, do you think that the instruments we have at hand right now are actually sufficient to stop the attacks on the independence of the judiciary, whether we speak about the European Court for Human Rights, the Court of Justice of the EU, or the Article 7 proceedings at the EU level that you mentioned. Is this actually sufficient and efficient enough?
Well, generally, it is a very complex issue, but to be honest, when we look at all of these rulings of both European courts, Polish government is mostly ignoring all of them. And even if we have, as I said, the confirmation that all of the actions of the government are violating when it comes to European standards, then the Polish government is ignoring them. So only one judgment was the one that I mentioned, according to which Polish justices of the Supreme Court were able to get back to the adjudication. But then, when we look at all of the others, the Polish government is generally ignoring these judgments. But what is important, these judgments of both European courts are very good tools in the hand of Polish independent judges. So they can use it in their adjudication in many cases where that kind of rulings of Court of Justice and Court of Human Rights are very useful to protect Polish independence of judiciary. Of course, we are permanently on the battle between independent judges and the government, and between independent judges and so-called neo-judges. We called neo-judges those judges who were appointed improperly through these new national judiciary councils. So those judges who are completely subordinated to the government and loyal to the government. So we are on a permanent battle when it comes to these independence of the Polish judiciary. But I can say that we are stepping forward very slowly towards winning this battle. And but answering a very straight to your question, if it is sufficient enough or not, I would say that the European Union institutions don't have enough sufficient tools in their hands, because as we can see, the only efficient instrument is blocking European funds, blocking money. It appeared that the most effective tool was the procedure of blocking European Recovery and Resilience Fund. We know that this huge program was worth 800 billion euro for the whole European Union, and out of it, 58 billion euro were designed for Poland, and Poland do not have even 1 cent out of it because of the violation of the rule of law. And the Polish government is trying to do their best to get this money from Brussels, so they made some concessions. Like, for example, they liquidated the disciplinary chamber, which was a crucial body in the repression machine against Polish judges. And they made some step back when it comes to destruction of the rule of law in Poland. But generally, of course, European Union have to look forward and look for the new instruments, more efficient instruments that they have right now. Because those instruments that are in the hands of the European Union institutions were designed in the past, having in mind that all the member states of the European Union are preserving those major values and like rule of law. And there is no need to have strong tools in the hand of the Commission or the Council to push the governments of the member states. Now we have a completely different situation. We have Hungary, we have Poland. So those are two black sheep in Europe, and we have to think about the future, how to preserve the rule of law more efficient than the European Commission can do that right now.
Yeah. Thank you very much for this insight. I must say I'd agree that really the Article 7 proceedings at the very least have been moving very, very slowly. And indeed, we have seen much more movement with the recovery funds recently. But I just also think it's very interesting to hear that even if the rulings of the courts have been largely ignored by the government, these can still be really useful in national litigation and further be used in front of national courts and actually move still in the right direction. I think this is really at least one positive sign. And I mean, I wanted to ask you also whether we could speak very briefly about some of the recent judgments of the national courts in Poland when the supremacy of EU law was put into question, and equally the Article 6 of the European Convention on Human Rights. Like this seems like rather serious judgments by Polish courts, kind of undermining the very integration of Poland in the European Union and in the Council of Europe. So, what does it tell us about the situation of the captured judiciary, and where might this actually be leading to?
Well, this is the question about Polish Constitutional Court, which was the first target of the assault, constitutional assault of the government in 2015, 2016. So since the end of 2016, we do not have in Poland independent constitutional court. I mean, the court which is responsible for assessing all the laws passed by parliament with the constitution. So this constitutional court, which is completely subordinated by the government and is following the line of the ruling party, they issued two judgments in 2021 saying that the Treaty on the European Union is unconstitutional. That was for the first time in the history of the European Union that the Constitutional Court of the member state issued the judgment saying that the treaty is unconstitutional. And the second one was about the Convention on Human Rights, and that was exactly the same that the Constitutional Court in Warsaw said that this convention, when it comes to the Article 7, to the guarantee of the independent and impartial court, is not following the Polish constitution, which is absurd, of course, because there is no difference between three standards which are described in the convention in Article 6, the independence and impartiality of the court, the treaty, Article 19, and the Article 47 of the Charter, and the Polish Constitution, Article 45 of the Constitution, saying that the courts are to be impartial and independent. So there is no conflict between the Polish Constitution and the Convention or the treaty. But these judgments of the Constitutional Court were following the line of the party to be able to argue in front of the Commission that, look, we do not have to follow the judgments of your court in Luxembourg, and we do not have to follow judgments of the Court of Human Rights in Strasbourg because these provisions of convention and a treaty are unconstitutional, which is, as I said, of course, absurd, but it shows very clearly how the situation with the violation of the rule of law in Poland looks like.
Thank you. Thank you so much for this insight. And I mean, finally, I would like to take a step back and ask you about the role of lawyers for a well-functioning democracy and the rule of law from your personal experience. Perhaps also, what are the biggest challenges for lawyers in the current circumstances in Poland?
Well, of course, the role of lawyers is extremely important because every tyrant needs lawyers, and they can work on the side of the autocracy and help to prepare the new legislations and help to prepare a new order, undemocratic order. But lawyers can also play a very important role when it comes to the protection of the rule of law and protection of the independence of judiciary. And I would say that Polish lawyers passed the exam when it comes to the protection of the rule of law, and they were very active since the beginning, from 2015, in the protection of the Constitutional Court, then in the protection of the Supreme Court, the common courts, and finally in the protection of individual judges and justices of the Supreme Court, because many of us are representing repressed judges in Polish courts as well as in European courts. We established Justice Defense Committee in 2018, and under umbrella of Justice Defense Committee, we have more than 200 proceedings against independent judges in Poland and against independent prosecutors. So we are providing legal aid for them. We are providing moral support for them. And this is the strength of the legal community. Also, when it comes to advocacy throughout the world, we are traveling to Brussels, we are traveling to Washington to describe the situation in Poland and to find the allies in the international legal community. So I believe that Polish lawyers played a very significant role within last 7 years in Poland, and they are still playing this role, because I believe that thanks to what we are doing and what Polish judges and prosecutors, those independent, are doing, we will be able to liberate in the nearest future, and that is one of the main factors, the important factors that lawyers have to be active during the difficult times.
Mm-hmm. Yeah, well, exactly. And I think everybody has been admiring also the courage of the lawyers, really stepping up and just going ahead with this work. So, yeah, I mean, on this note, hopefully there is hope in the future for lawyers and for judges and for the people of Poland and other countries in similar situations. And yeah, really thank you so much for your important work. Thank you for being our guest today. It was really inspiring talking to you. And good luck. Thank you.
Thank you very much.
Thank you for listening to the Judicial Independence Podcast.